You know, every single time you click a button, post a comment, or buy something online, you're not just browsing, you're stepping into a really complex legal world. There's this huge web of rules that governs our digital lives, but what are they exactly? And who gets to make them? In this explainer, we're going to demystify the legal obligations that are shaping our online reality.
This analysis is based on the works of Professor Vihar Kiskinov, and our guide for this entire journey is right here on the screen. I want you to think of this mind map as our roadmap, laying out all the key concepts we're going to explore together, from the very foundations of digital law all the way to the cutting edge of AI regulation.
So, here's a quick look at where we're headed. We're going to start with the core concept. Then we'll dive into the different kinds of digital obligations. After that, we'll see how they're enforced and unpack the brand new rules for AI. We'll also look at how this whole area of law is constantly changing. And to wrap it all up, we'll look at a specific real-world example of these principles in action.
Okay, let's start at the very beginning. Before we can really get into the details, we first need to get a clear handle on what we actually mean when we say a legal obligation in this digital space.
The easiest way to think about digital legal obligations is to see them as the traffic laws of the internet, right? They're not just helpful suggestions. They are the mandatory, binding rules that everybody has to follow to keep our digital world running smoothly, safely, and fairly. And just like traffic laws, it's all about finding that really critical and often delicate balance between individual freedom, public safety, and the forward march of innovation.
Now, what makes these rules so incredibly unique and, frankly, so challenging is what you see here. They can cross borders in an instant, which makes purely national laws really tricky to apply. They have to change all the time just to keep up with technology. They are deeply technologically complex, and because of all that, they demand completely new ways of thinking about control and enforcement.
All right, so now that we have a basic idea of what these obligations are, let's break them down. We can split them into two main categories, and this will really help us understand who is responsible for what out there in the digital world. So, on the one hand, you have private obligations. These are the rules that govern how we interact with each other and with companies online. You know, when you sign up for a social media account, you're basically entering into a contract, and that creates duties for both you and the company. But on the other hand, we have public obligations. These are the duties we all have to society to keep the internet safe for everyone. This covers things like not spreading illegal hate speech or engaging in cyberbullying.
And this is where things get truly fascinating. It shows just how fast the law is racing to keep up. With technologies like brain-computer interfaces on the horizon, we're seeing a whole new category of rights start to emerge: neuro-rights. This is the radical idea that our actual thoughts, our mental privacy, have to be protected from being accessed or manipulated. It's a brand new frontier for digital law, and I guarantee you we'll be hearing a lot more about it in the years to come.
You can really see this challenge of adaptation when we look at virtual assets, like cryptocurrencies or NFTs. As you can see here, there's just no single unified approach. Germany, for example, doesn't consider them physical things, so they can't be stolen in the traditional legal sense. France went and created a whole special category for digital assets. The UK is talking about creating a third category of property, while Bulgaria, for now, doesn't have a specific regulation. It just goes to show you that this is a global legal system trying to figure things out in real time.
Now, this quote comes from a huge case that really made headlines. It was Hermes versus Rothschild. The luxury brand Hermes sued an artist who was creating and selling NFTs of their famous Birkin bags. The court actually sided with Hermes, and the reasoning was fascinating. They said the NFTs weren't just lines of code, they were virtual objects that violated Hermes's real-world trademark. This case is a perfect illustration of how old laws are being stretched and adapted to fit these new digital realities. So, we've talked about what these digital obligations are and the different types that exist. But how are these rules actually enforced all over the world? Let's dig into that in this next section.
I mean, this is the big question, isn't it? The sheer scale of the internet makes traditional enforcement seem, well, almost impossible. So how on earth is it done?
Well, there are two main ways this happens. The first is the traditional way, with laws and courts and regulators. But in the digital realm, that's often too slow or just not enough. And that's where the second method comes in. This idea that code is law. This is the principle that you can build the rules directly into the technology itself. A great example is a social media platform using an algorithm to automatically find and remove prohibited content, sometimes before it even spreads. Here's a very concrete example of this hybrid approach. Major tech platforms have committed to a clear process for dealing with illegal hate speech. It all starts with a user report.
The platform then has an obligation to review that report in under 24 hours, and if it violates the rules, remove the content. To make things more efficient, they also partner with special organizations called trusted reporters, and their reports get put at the front of the line. It's a really interesting mix of user vigilance, corporate responsibility, and technological speed.
All right, let's shift gears a little and talk about one of the most significant developments in digital law we've seen in years, the European Union's AI Act. This is a really groundbreaking piece of legislation, and it's going to have a major impact on how AI is developed and used, not just in Europe, but around the world.
So the Act starts by setting a baseline of obligations for all AI systems. It doesn't matter what they do. Every single provider has to conduct a risk assessment. They have to maintain detailed technical documents so we can understand how it works. They have to log its activities so it's traceable, and they have to be ready to cooperate with national authorities. These are the new, basic rules of the game.
But for systems that are considered high risk, and you can imagine what that includes, things like AI and critical infrastructure, medical devices, or law enforcement, the obligations get a lot tougher. These systems need a robust risk management system. They must use high-quality, unbiased data to prevent discrimination, and, this is crucial, they must allow for effective human oversight. A human being has to be able to step in at any time.
And all of this brings us to a really important overarching point about digital law as a whole. It's not this fixed, static thing. It's constantly in motion, constantly changing and evolving, just to keep up with the latest technology.
And this evolution really happens in two different ways. On one hand, legal duties that already exist get enriched with new meaning. So, for example, the traditional duty of loyalty in a contract now implicitly includes an obligation to provide good cybersecurity. But on the other hand, entirely new technologies, like AI, force us to create brand new legal frameworks completely from scratch.
You know, this leads to a fascinating, almost philosophical debate. In traditional law, rights and obligations are often seen as two sides of the same coin. But in the digital world, as our rights expand, is it possible or is it even desirable for our obligations to grow in perfect symmetry? Or has the very nature of the internet broken that traditional balance? It's something to think about.
To bring all of these abstract ideas together, let's look at how these principles are actually applied in the real world. We're going to zoom in on one country, Bulgaria, and see how they're tackling the challenges of digital law.
Bulgarian law puts a really strong emphasis on using technology to promote transparency and public access. There are legal obligations for government bodies to provide information to the public online, to accept official e-documents, and to offer e-government services. A very powerful recent example of this is the new legal requirement for real-time video streaming of the vote-counting process during elections, using technology directly to ensure public oversight and to build trust in the system.
So, what's the bottom line here? The main takeaway is that digital law is this constantly evolving field that's basically in a race to keep up with the incredible pace of technological change. The key challenge, both for today and for the future, is finding that right balance, that sweet spot between protecting our fundamental rights, keeping us safe, and still allowing for the innovation that makes the digital world so exciting in the first place.
And that brings us to our final question for you. As our digital and physical lives become more and more intertwined, who should be the one writing the rules? Should it be the governments that we elect, the tech companies that build the platforms we use every day, or should all of us have a say in shaping the future of our internet? The answer to that question will really determine the future of our digital world.